Please be seated. We will swear.
All right, good day, everyone. A counsel for the defense. Mr. Haynes, you used 45 minutes this morning. Were you completely finished with your submissions? Did you want, because you did have more time, did you wish to use any more of your time allotted, particularly in respect of the submission that you made as to the outcome?
Your Honour, no, thank you.
All right, very well, thank you. Prosecution. You have the floor.
Madam President, Your Honours, counsel representing the rights and interests of Mr. Kony, Mr. Haynes, has declined to challenge the prosecution's evidence and to make submissions on the nature and scope of our charges. After appealing Your Honour's decisions and failing, then asking for reconsideration and failing, counsel is now advancing another idea, the stay of proceedings. Your Honours, this amounts to an impermissible request for reconsideration. And a stay on proceedings is also entirely unnecessary to safeguard Mr. Kony's rights. Mr. Haynes explains this new idea with the scope of his mandate. A mandate which is supposed to protect the rights and interests of Mr. Kony, a suspect who also has the right not only to a robust defense, but efficient and speedy proceedings. It's Mr. Haynes' discretion, his choice, how he sees fit to fulfill his mandate. But what came today was yet another idea on how to end these proceedings, rife with legal and factual speculation, diametrically opposed to the laws of this court. Importantly, as Mr. Haynes himself acknowledges, Your Honours have put all safeguards in place to allow the defense to exercise its role meaningfully. Sufficient time to prepare, inter partes disclosure communications, litigation, speedy decisions on such issues. The defense has had every opportunity to engage meaningfully on the document containing the charges, the prosecution's disclosed evidence, procedural issues, disclosure issues. And they have shown that they can. They've just decided not to bring that to this hearing. Mr. Haynes' views are not reconcilable with how these proceedings have been overseen by Your Honours, and also not with the statute. A stay of proceedings is completely out of the question. According to appeal chambers jurisprudence, for instance, in the Lubanga case, decision number 2582 at paragraph 55, a stay is a drastic remedy. According to the trial chamber in Lubanga, it must be demonstrated that it would be impossible to piece together the constituent elements of a fair trial. While, Your Honors, the biggest obstacle to a future trial being held, in fact, the only obstacle, should you decide to confirm the charges, is Mr. Kony's continued absence. Everyone agrees that no trial can proceed without him. Ordering a stay would do nothing additional to safeguard his rights. All it would do would be to frustrate the pursuit of justice by depriving the victims and affected communities of a decision on the sufficiency of the evidence to substantiate the charges. With your decision, Mr. Kony will either be committed to trial or he will not. And of course there will be a confirmation decision. Article 61 demands it. Article 61(7) is directly applicable to confirmation proceedings in absentia, which states that the pretrial chamber shall, on the basis of the hearing, make a determination on the sufficiency of the evidence. And accordingly, Regulation 53, that the pretrial chamber's written decision shall be delivered within 60 days from the date the confirmation hearing ends. Article 61(11) requires that the presidency, should you confirm the charges, constitute a trial chamber. So there should be no doubt, if you decide to confirm the charges, this case goes to a trial chamber. An actual trial, of course, can only start upon arrest. Mr. Kony, once arrested, would be by no means without rights. Mr. Haynes has identified the correct rule, which should, as all rules, be interpreted in light of the rights enshrined in Article 67 of the statute. And we recognize Rule 126(3) only mentions the term fled. But, Your Honors, the appeals chamber in this case, in its decision number 610 at paragraphs 47 to 48, has ruled that there is nothing intrinsic to the terms fled or cannot be found that makes them mutually exclusive. Further, to interpret the rule as only applicable to persons who fled would lead to the paradoxical situation that persons who have been deemed cannot be found would not fall under the second limb of this rule. And while Article 64(4) allows a trial chamber to refer preliminary issues to the pretrial chamber, the appeals chamber has also certified that in these proceedings, robust safeguards to protect the suspect's rights have been put in place. Mr. Haynes speculates about what may or may not happen after this case moves to a trial chamber, should it move to a trial chamber. And we all cannot predict the future. But several things are for sure. This court retains jurisdiction, and the case before you is admissible. Based on the referral, based on previous decisions of this court, notably Appeals Chamber's decision 408. While the text of the referral is confidential, Your Honors have it on the case record. You can appreciate it. And you can see the limitations, the defense interpretations, and that these interpretations are without merit. There are no changes in circumstances. The position of Uganda remains the same. Nothing else has ever been communicated to this court. Mr. Haynes has not provided any official written communication supporting his claims. It is a fact that there are no national proceedings against Mr. Kony in Uganda. And any insinuation of future national proceedings is purely speculative and not based on a meaningful dialogue, discourse, or engagement by the court with the authorities of Uganda. In fact, the documents before you on the case record show that the International Crimes Division, ICD, was never meant to supplant the court with regard to top LRA leadership. Second, Your Honors, should Mr. Kony be arrested, he is free to challenge admissibility and any other issues, like any other suspect arrested. Importantly, whether he or Uganda go down that path, it will always be for this court to have the last say. Thirdly, none of the arguments advanced relevantly challenge the integrity of the proceedings that you have overseen. What matters is the evidence, whether it meets the test required at this stage, which the defense has chosen not to touch upon. What matters are the thousands of people from affected communities in northern Uganda following these proceedings as we speak, hoping for justice. What matters is that this court delivers on its mandate, which is to ensure that the most serious crimes of concern to the international community must not go unpunished, and to end impunity. That's what these proceedings are about. Mr. Kony is a wanted fugitive accused of the most heinous crimes. In order to allow for his prosecution, Your Honors have put in place robust processes to safeguard his rights and interests. And it now falls on your decision on the evidence before you. Should Mr. Kony be committed to trial or not? And the prosecution's plea is unequivocally yes. Before I close, I would briefly like to address the request made concerning changes to the legal characterization in counts 27 and 36 by my colleague, Mr. Bradfield. The prosecution stands by its approach to charging for the following reasons. We have charged the crime of enslavement within our discretion under the statute as an overarching crime. Because first, this crime incorporates all indicia of enslavement experienced by women, girls, and boys under 18 within the LRA during the charged period, thereby putting the criminal acts in their proper context. It allows for greater number of victims to be considered. All acts relevant to sexualized forms of enslavement, the control of sexual and reproductive autonomy, can constitute enslavement as well, including grooming young girls as ting-tings to be future forced wives, and suffering endured by children born to enslaved women. And it avoids arbitrary fragmentation of harm suffered. Our charging approach will not cause an impunity gap. Quite the opposite, as there is no conduct which is not covered. It also does not render the crime of sexual slavery redundant, because we have charged on the facts of this case and nothing else. Finally, any decision on this issue should be incorporated in your decision and not be decided outside it or before it. The charged crimes are based on specific material facts, and each fact is supported by sufficient evidence. This includes the evidence on estimation of the minimum numbers of victims for each count, including the counts for enslavement. Mr. Kony, as the leader of the LRA, used the hierarchy of the LRA to control its fighters, to subjugate them to their will. He exercised control by virtue of essential contributions, and he wanted LRA fighters to commit the charged crimes. It's all there in his own words, based on evidence found to be probative and reliable, including the intercept evidence, by Trial Chamber 9, whose decisions was upheld on appeal. Let me conclude with the following remarks. I wish to stress that the efforts to secure Mr. Kony's arrest and surrender are continuing and will continue. The Office of the Prosecutor and the Registry are working together with our partners to finally locate and apprehend Mr. Kony so that he can appear before court. We will not give up on this such important objective. It remains our ultimate goal. But meanwhile, Your Honors, you have moved this case forward. Whatever outcome you decide will be based on the evidence before you and be in the interests of justice. I conclude my submissions by commending the witnesses and victims in this case. I have had the honor of meeting quite a few in northern Uganda, and the conversations have directly influenced how the prosecution has approached its case. I would have welcomed to be in Uganda today, but I wish to tell victims and witnesses sincerely that this today is not the end. The Office of the Prosecutor, though far away here in The Hague, continues to pursue justice in this case. And finally, I wish to thank you, Madam President, and Your Honors, and the Chamber staff. I also thank my colleagues from the defense team, the victims' representatives, as well as those from the registry here and behind the scenes, interpreters, transcribers, audiovisual staff, who have supported this hearing. It has been a true pleasure to work with such professional and dedicated staff and legal minds. May this not be the end, but a new beginning. I thank you for your attention.
Thank you, Counsel. All right, we have the final observations of the CLRV.
Madam President, Your Honors, my name is Joseph Manova, and together with my colleague Francisco Cox, we will be making the closing remarks on behalf of the CLRV. Madam President and Your Honors, the defense yesterday in their opening statements attempted to minimize the role of victims in these proceedings to merely seeking compensation and or reparations. The ICC accountability process triggered in these confirmation charges hearings and proceedings during the last few days provides victims with an important facet of victim healing, which is participation. Many victims of Joseph Kony and his LRA fighters fighters' crimes have not spoken to anyone about their personal or individual victimization on the day the respective IDP camp was attacked, or as it were, on the day they were abducted and forcefully taken to the bush in the charge period, namely 1st July 2002 and up to 31st December 2005. They thus have carried with them a survivor's guilt for many years, and some have indeed died with this guilt. They hold themselves guilty for not doing something to avoid or escape the victimization orchestrated by the LRA under the leadership of Joseph Kony. Participation in these proceedings, and hopefully in later proceedings following on from this Chamber's decision, hopefully confirming the charges against Joseph Kony, will allow not just for the truth behind the violent attacks on civilians to be told, but through the CLRV, most victims will be able to get a listening ear of someone patient enough to listen to their unique audios of victimization, and who in turn will bring it in due time to the judges and the world to know their story of emotion, pain, and suffering. Participation in the court proceedings will thus provide victims with agency to tell their stories of the LRA violence. It is well established and accepted, Your Honors, in international law that accountability goes hand in hand with redress and harm suffered. Victims' participation in these proceedings lays a foundation for accountability to culminate into repair of all harms the victims have suffered. Whilst it is true that many victims from a number of other proceedings await reparations attributed to the lack of resources from the Trust Fund for Victims, the outstanding proceedings, including this one against Joseph Kony, should rally states parties to commit more than before to the plight of victims by taking measures to prepare to repair victims' harm in advance. This is because states have resolved to end impunity for perpetrators of serious international crimes. It is apparent from these proceedings that only a handful of victims, about 5,795, have been granted status to participate, again owing to the limited time set by the pretrial chamber. Many would have loved to apply and participate in the proceedings that have been ongoing on. However, that was not possible. Those victims that we represent appreciate the opportunity to participate in these proceedings and the significance to hold these proceedings. Victims welcome and acknowledge the promise to promptly commence the trial in the event that Joseph Kony is apprehended, post the confirmation of charges against him. Your Honors, the prosecution evidence shows that the suspect Joseph Kony is the leader and overall commander of the notorious LRA armed group that sought to take power by force of arms in Uganda. He organized himself and the LRA in such a way that he had commanders below him and with whom he relayed orders and spoke with on LRA radio. He planned and gave directions on carrying out attacks and receiving reports on attacks and awarding active commanders and those below them with rank promotions. Your Honors, the suspect, Joseph Kony, was manipulative. He used promotions in the LRA regular members on the one hand, and the distribution of girls as so-called wives as a reward mechanism to prevent escape from the LRA. He combined this with demanding and implementing severe punishment, including death sentences for all who attempted or planned to escape. These sentences were carried out by commanders and others below them to retain fighters. Joseph Kony was sadistic. Whilst he loved his life and protected it jealously by staying at command altar, detached from his commanders for his own safety, he did not care for and value human life as he did his own. He was happy to order attacks on any civilian settlement, including Odeka IDP camp, where his own family would have been resident during the attack. The prosecution evidence shows that he, for example, congratulated Dominic Ongwen for the attack on Odeka IDP camp and other IDP camps, where many victims lost their lives. Children were abducted and taken away from the love of their parents and family, and also suffered the terror of the attack and the ensuing violence and fear that followed the attack and captivity. Your Honors, when the defense visited Uganda prior to the commencement of these hearings, the defense was reported by news reporters in Uganda to have told the Prime Minister of the Acholi Cultural Institution, Mr. Michael Tim, that the defense wanted to understand the victims' perspectives on the court's move to confirm charges against Kony in absentia. Mr. Tim was reported to have also noted that the visit by the Defense Counsel made a good gesture for victims of the LRA atrocities who have had to wait an exceptionally long time to see justice, as remarked by our colleague in her opening statement. It was similarly reported that the justice must be relevant to the victims and deal with their justice questions, including harm suffered. This is a report, as I have indicated, Your Honors, coming from the important cultural institution of the Acholi. During the last couple of days, Your Honors have heard from the presentation made by our colleagues in their respective opening statements, and on the charges for which Joseph Kony is charged with the grave and atrocious nature of all the attacks and disregard for human life and property which characterized the LRA attacks on civilian targets. These criminal activities by the LRA under the overall command of Joseph Kony and executed and brought about by commanders who agreed with him to realize the common plan, implemented and actually achieved the intended outcome of the common plan on innocent civilians, including our clients. The prosecution evidence demonstrates that the LRA, under the overall command of Joseph Kony, was a rebel force fighting within the territory of the Republic of Uganda, a state party to the Rome Statute. The fighting was violent and particularly localized to the greater northern Uganda, covering several districts hence the attacks on the charged locations, as we have heard, on Luala girls in Kabramaido district, Pajule IDP camp in Padre district, Abia IDP camp in present-day Aleptong district, Balonyo IDP camp in Lera district, Odek IDP camp in present-day Omoro district, Pagak IDP camp in Gulu district, Lukodi IDP camp in Gulu district, and the Bok IDP camp in present-day Oyam district. Your Honors, notwithstanding that school girls at Luala Girls Secondary School and the residents of the respective IDP camps I have named were young and innocent and civilians respectively, these specific locations that the LRA targeted were also places of learning, displacement, vulnerability, refuge, and safety that ought not to be attacked. The LRA attacks in the said locations were thus deliberate and aimed to specifically, 1, take food items from an already vulnerable and food-deprived population dependent on the World Food Program for food rations. 2, take property of all forms and nature, and thereby disempower and render the residents of the IDP camps destitute. 3, forcefully take young girls and boys with the intention of enlisting them into the violent LRA organization, and thereby effectively deprive and destroy not only their childhood, but their humanity. The LRA organization therefore had no regard for life or property. And finally, exert and impose fear and trauma on its victims and abductees to ensure compliance and scare the abductees against escape. Your Honors, the prosecution evidence has also shown that Joseph Kony encouraged his commanders, with whom he agreed to carry out attacks on civilian targets, with the aim of the outcome being genocidal in nature. He intended for the IDP camp residents to be totally wiped out, owing to victims being compelled to move to IDP camps for safety, which action was viewed by Joseph Kony and his LRA commanders as not supporting the LRA. To this end, each attack on a charged location was characterized by terror and unprecedented violent death. In some cases, such as Balonyo, up to 300 people were killed in just a single attack, and individuals dehumanized, deliberate abductions of children, and massive properties looted or simply destroyed, indiscriminate shooting and torching of houses in the IDP camps as well. The harm suffered as a result of gender-based violence, the harm suffered as a result of gender-based violence are manifold. They touch both the girls and women who were the direct victims of these crimes, their children, and their wider family. It extends from a wide range of health issues to psychological trauma, lack of agency and personal autonomy, poor socio-economical outcomes, family cohesion, and subsistence issues, forced displacement, stigmatization, and community issues, including rejection, loss of family links, delinquency, and economical harm. The experience of forced conscription into the LRA varies in scope and intensity, but is always considered to be traumatic. Children and youth, some as young as 7 and 8 years old, were forced to mutilate and kill civilians, including members of their own families and communities. Abductees also have had violence inflicted upon them, typically beatings, imprisonment, forced labor, and witnessing horrendous acts of violence. Abductees who have committed or experienced high levels of violence show substantial increase in emotional distress, as well as poor family relations. Your Honors, what former abductees went through in the bush had a profound impact on their ability to reintegrate in their families and communities upon their return. About 21 years after the LRA attacks on the charged locations, the suspect, Joseph Kony, is still at large and hiding from being held criminally responsible. In this same period, amongst the then survivors of the attacks on the charged locations, we estimate about 500 victims from the locations of Obok, Odek, Lukodi, and Pajule have lost their lives without seeing in person justice being done and receiving reparations from the crimes committed against them. The other victims, of course, continue to survive after the impugned attacks and are still alive, as many would say, by the grace of God, to demand for justice and reparations for the crimes perpetrated against them. They count on the efforts of the international community to apprehend Joseph Kony and have him prosecuted before this court. Your Honor, that ends my remarks, and I will invite my colleague Francisco Cox to conclude our statements.
Thank you, Counsel. Yes?
Madam President, Your Honors, thank you for the opportunity to addressing you on behalf of 5,795 victims. Your Honor, I would like to insist on our request made by my colleague Paul Bradfield in terms of including sexual enslavement. Your Honor, legal characterization is important for victims. Invisibility is something that hurts victims. And I think the question is very simple. Can you enslave somebody without committing sexual acts? I think the answer is yes, you can. And if you answer that in the positive, then it's clear that enslavement does not cover all the interests that the drafters and the international community wants to protect by charging and by confirming charges eventually of sexual enslavement. This is important for victims because, and it always surprises me how lawyers that have no contact with victims believe that their only interest is money. When we go to the communities, they tell the court what happened to us. Of course they want reparations, and it's a right. There's nothing bad about reparations, but it's not the only thing they want. So when they say, tell what happened to us, it's not just the facts that matter. It's also how a high court like this one characterizes what happened to them. Therefore, the lack of the charge of sexual enslavement is saying that that didn't happen really, not in the legal point of view. I understand that in the facts, they are there. But tribunals have the competence of the competence. So you have the power to characterize the facts. It's within your domain as what is really in the legal world. Criminal law plays a fundamental role in reaffirming norms and values that we hold dear to us. So that's why we must insist on the request made by my distinguished colleague, Paul Bradfield. With regards to the submissions of the defense, Madam President, Your Honors, I must be honest. I find it creative. I found it interesting, but I also found it with no legal basis. What my learned friend is asking you to do is to eliminate Article 61(2)(b). The natural consequence of holding the procedures, because there might be, he might appear, there might be expensive proceedings, there might be violations of rights or everything he said. Well, then why did the framers put the possibility of in absentia charges? And it's that, I think, not only smart, not only creative, interesting, but also smart, because he's trying to relitigate what he already lost. The appeals chamber and the decision, confirming the decision to move forward in the absentia confirmation of charges in paragraph 75, take care of the concerns my learned friend presents to you about the rights that he can exercise when he shows up. Let's not forget that. It's his determination, his will to be absent. Madam President, my learned friends from the defense are right that the people that are victims of the crimes of Joseph Kony are much more than 5,795. None of the lawyers who represent those people, and I must say, because I like to say this every time, these are each individual people. They're not victims. They're not a number. They are actual people. And we know that the crimes that Mr. Kony committed with his co-perpetrators affected much more people than 5,795. And what's more important, the people that we represent know this. They understand that they are a very small portion of those affected by the crimes that my learned friends have to represent the suspect. But in no way can this be understood as if they don't want a broader picture to be shown in this courtroom. You are well aware, Madam President, Your Honors, that the scope, the geographical scope of this case is much broader than the one that was brought up with Dominic Ongwen. So it would be a little bit strange that because there's a few number of people participating, then you want to shut the first step in the road to justice. It doesn't make sense that this would be in the interest of ending impunity, which is the purpose of the Rome Statute. A canon of interpretation that must illuminate all of your reasoning. And, Your Honors, we haven't met at least I haven't met the Minister of Justice, nor the President, nor the most powerful leaders of Uganda. No. We've met those who we represent, simple people in the communities suffering the consequences of the crimes of Mr. Kony. And it puzzles me because what they say is that they want justice. They want you to confirm these charges because they know, because they lived through it, that there is more than substantial grounds to believe that Joseph Kony is responsible for the crimes that he's being charged today. And they understand. It also always puzzles me why there's this paternalistic view among victims in the communities that, oh, they'll get confused. No, they understand. My colleagues that went to the communities told them, look, we can't move on if Joseph Kony doesn't appear. They know this. Why is it that they believe that people are confused? They might be frustrated, yes, of course. But confused, they know. We've told them. We've done our job. My colleagues have done their job. And like I say, victims want truth. And it's in their interest, and it's their right. As Judge Antonio Cansado Trinidad, in paragraph 32 of his concurring vote in Bamaka versus Guatemala, back in 2000, said the right to truth is intertwined with the realization of justice and guarantee of non-repetition. So it's an individual right of those who we represent, their families. But not only is it an individual right, it's also a collective right, because by sanctioning these crimes, you are trying at least to affirm a guarantee of non-repetition and to end impunity for such crimes. But not only the international community has an interest in justice. And this is why I was particularly surprised, and we talked among ourselves in the team, when we heard that the community leaders were not interested in justice, that they didn't like the ICC, that they found it self-interested. On 19th of May, 2016, my friend and colleague Joseph Manova, myself, Ms. Jane Odong, may she rest in peace, a former lawyer working for OPCV, and Paul Bradfield. He was in the prosecutor's office at that time. We went to Lukodi to commemorate the massacre in Lukodi. and that's not interesting to you, but what might be interesting to your honors is that in that commemoration, who spoke was the paramount Acholi leader, Mr. Wowok Achana. You see, that's why Joseph corrects me rightly. And he said, and this is very interesting, Your Honor, well, I find it interesting, that he said that he personally had a personal gratitude towards Joseph Kony and Dominic Ongwen because there was a plot to assassinate them in one of the meetings that they had in the peace process, and that Joseph Kony and Dominic Ongwen spared his life. But despite that, he said that just as if Dominic Ongwen has committed crimes, he must face the proceedings. And he also said, Acholi land has soaked up the blood of innocent people and called upon all the people to support the ICC trial. So we have victims that support these proceedings. We have the paramount chief of the Acholi land. And also, we have a decision by the Supreme Court of Uganda that mentioned, it's in the, I'm really going to pronounce this bad, Kowayelo case before the Supreme Court on an appeal from the Constitutional Court about Mr. Kowayelo was saying that he had been discriminated because the amnesty had not been granted to him. And the Supreme Court determined that the person who commits such crimes may be eligible for amnesty for the act of rebellion or waging a war on Uganda. But he is not, in my view, entitled to amnesty for grave crimes he may have committed. So even the amnesty law enacted in Uganda would not grant amnesty to such grave crimes. But furthermore, Your Honors, Article 21, number 3 is clear that the application and interpretation of law pursuant to this article must be consistent with international recognized human rights. Your Honor, I thought I was going to speak tomorrow, and this might be absolutely irrelevant to you, but tomorrow is the 51 year since the military coup in Chile. I come from Chile. So we know about this discussion of truth and reconciliation, transitional justice, and it always surprises me that the powerful are concerned about reconciliation, but they never ask the victims. The victims, the ones that suffered the consequences of the crimes, the ones that were raped, that were killed, that were disappeared, they have no voice in this, it seems. It's among the powerful that decide. Fortunately, the Inter-American Court of Human Rights has dealt, because of this long-standing practice of our leaders to wanting to grant amnesty laws for grave human rights violations, has abundant case law talking about the incompatibility of human rights standards with amnesty laws. Just to quote some cases, Barrios Alto versus Peru, Almonacid versus Chile, Gelman versus Uruguay. So this regional body has again and again said that you can't establish statute of limitations, amnesty laws against these grave breaches of crimes. And a similar reasoning was done in by the ICTY in Furunziga, in paragraph 155, where they talk about the prohibition of torture and how it would be strange that if you have a prohibition of torture, then you would give amnesty for torture afterwards to public officials. Your Honors, even the Human Rights Court, which is more cautious on establishing a blunt prohibition on amnesty laws, in the case Margus versus Croatia, that's my Spanish kicking in paragraph 139 states, in the present case, the applicant was granted amnesty for acts which amounted to grave breaches of human rights, such as intentional killing of civilians, inflicting grave bodily harm on child, and the country court's reason referred to the applicant military officer. A growing tendency in international law is to see such amnesties as unacceptable because they are incompatible with the unanimously recognized obligation of states to prosecute and punish grave breaches of fundamental human rights. Even if we were to accept that amnesties are possible where there are some particular circumstances, such as reconciliation process and or form of compensation for victims, the amnesty granted to the applicant in the instant case would still be not acceptable, since there is nothing to indicate that were any of these circumstances in the case. Your Honors, I convey to you that that is exactly the case in Uganda. There is a policy on transitional justice, but there's no truth commission. There's no real reparation process going on. There's nothing similar to a transitional justice process occurring in Uganda. It is for all these reasons, Your Honor, that victims request that you dismiss the allegations from the defense and confirm the charges. We believe that the prosecutor has met the standard of substantial grounds to believe, and victims don't want this to be interrupted. There is still a misunderstanding of what victims want. Staying the proceedings, it's not, Your Honor, that they wanted to be heard or they wanted someone to read in this court. They follow these proceedings in Uganda, and they follow them massively. When they are screening, thousands of people show up. It's because they're interested that an official body, an international body, the body created to end impunity in 1998, delivers justice. This is the first step. So this is why we ask for the confirmation of charges. Thank you, Your Honor.
Thank you, Counsel. Mr. Haynes, or the defense, you now have the opportunity to make your final observations.
Yes, I'm conscious of your direction at transcript T15, page 5, lines 13 to 14, that remarks at this stage should be responsive, and so I'll be very brief. I'm sure that Mr. Manoba either misspoke or misunderstood the submissions that were made yesterday in our opening statements. Nobody on this side of the court sought to minimize the participation of victims in this process by reducing their interests as financial only. I myself was the legal representative of victims at the Special Tribunal for Lebanon, and behind me, Ms. Gibson, Mr. Gosnell, and many of this team have represented victims in many fora. No such thing was suggested, but perhaps Mr. Manoba's inability to understand Acholi, the language in which I think the submission was made, explains the remarks, but they were both professionally insulting and I think to Mr. Anyuru, who lived through the civil war in Uganda, personally insulting. And I would be surprised if Mr. Minoba wished to leave those remarks on the record, and they're at page 77, lines 5 to 8. Similarly, I was a little troubled by Miss Braun's submissions at page 73, lines 5 to 8. I thought we'd conducted these proceedings with a degree of collegiate respect, and I would expect counsel to respect the fact that if I said I had a meeting with the President of Uganda and he told me certain things, that would be expected, that would be accepted. As it happens, Mr. Gosnell was there with me too. I could happily put him on the witness stand if that was seriously contested. One submission only. The elephant in the room is this has to stop somewhere. And it doesn't matter whether you call it a stay or an adjournment or some other order of the court. Without an accused, this case is at a dead end. And in the circumstances, given that it has to stop somewhere, a stay prior to the issue of a decision is not drastic at all. And that's all I wish to say.
Thank you very much, Mr. Haynes. All right. We had anticipated that this confirmation of charges hearing would have ended tomorrow, but it has ended today. So this brings us to the end of the confirmation of charges hearing. The Chamber will issue its decision accordingly within the set time frame. Before closing, I would like to thank, in fact, we would like to thank the parties and participants. The submissions were useful, often heartfelt by all the parties and participants. And we would also like to thank the interpreters, the court officers, the technicians, the security officers, all of the representatives of the registry for their professional cooperation. And last but not least, we would like to thank the members of the public who were interested enough to stay here and listen on to the proceedings for 2 days. And if there is nothing else, then this hearing is at an end today. Very well then. Good day to all.
All rise, we will lever.
Okay, that marks the end of Kony case.
Very well then. Good day to all.
All rise, we will lever.
Okay, that is it. Kony case confirmation of charges hearing. It has been concluded today. Now let's wait for the decision of a court. What's next? And we'll be here to give you exactly what the court has decided and what's the way forward. But we hope the real Kony be God. And everyone knows the real Kony is General Kaguta Museveni. That's the real Kony. Museveni can't survive without wars. He formulates wars for him to get funds, donation from the West for his own agenda. But now, whatever was done, he is answerable. Let's wait for that day.